Trump is poised to further restrict H-1B visas. A document has been delivered to the White House by 3 governmental agencies, as requested by the president, to further restrict H-1B visas and other non-immigrant work visas. We don't know what the document says yet, but we're going to take some guesses and go through it now. Hi, I'm Jon Velie, immigration attorney and CEO of OnlineVisas, the intelligent immigration platform. We believe that there will be 3 significant elements to the yet-to-be-released proposal or final rule. It will be an interim final rule. It will restrict the definition of specialty occupation for the H-1B visa, and it will substantially impact third-party client location visa petitions. All right, let's go through those. Number 1, interim rule. An interim rule prevents affected stakeholders from submitting comments before going into effect. Will likely be rationalized as a response to the economic impact of the pandemic. Fortunately, an interim rule is less likely to survive a court challenge on the narrow question of whether avoiding public input was necessary, as DHS previously saw in its interim final rule on optional practical training. The economic situation has improved since March and April, and the terms of the H-1B specialty occupation and employer-employee relationship has existed since 1990 to 91 and were not challenged during other periods of economic difficulty. More importantly, USCIS lost a court challenge when initially rolled out the STEM OPT regulation as an interim final rule. The agency was unable to justify the use of that mechanism and was forced to start the process all over. Also, USCIS is just coming out of being slammed by an H-1B case called IT Surveillance versus the head of the USCIS agency. Because of this, it's going to show that this is a fix, but it does not need to be run so quickly as to not have the public and stakeholders be able to give their understanding or feedback on this rule. Number 2, restricting the definition of a specialty occupation. The summary of the rule that came out earlier from the president stated it would revise the definition of specialty occupation. Lawsuits U.S. Citizenship and Immigration Services lost earlier this year provided clues to the new regulation. So what do we expect this revision to be? Well, 1, let's look at past agency practice to restrict the specialty occupation from the database ONET to the database OOH. ONET is something that we've used as immigration practitioners for years. There was a list of occupations, and it would have data on the percentage of people that held various types of degrees, whether they're bachelor's degrees, maybe an advanced degree like a master's or PhD, or say an affiliate degree or no degree. That's what told us whether or not most people needed to have a degree to get that specialty occupation. In recent years, they've turned to the OOH. That's the Occupational Outlook Handbook. It just has less jobs. So the question will be whether or not this regulation will be tied to that database. And if a job is not listed in the OOH, will it be included? Or in some instances, the job is listed, but it's not defined very well. Will those be excluded? Some of those examples are very sophisticated jobs, such as a software architect or a quality assurance tester. Those are definitely professional jobs that require degrees, as a architect is more senior to a senior developer, but yet will USCIS use that just to limit these jobs? We'll have to see at that. We can also look at the national interest exemption that was just issued in August to permit certain H-1Bs to enter despite the presidential proclamation banning them in other visas, right? The new factors have been set forth to allow H-1B visas to be issued by consulates when at least 2 of 5 factors are met. So what are some of these factors, and will they be in this new rule? One of them, if the applicant is currently performing or able to perform those essential functions remotely outside the United States, they cannot enter the United States to do that. Now, that is probably too tied to COVID to be in this regulation, which intends to go forward as the new rule on H-1B. So I would doubt to see that element there. Another factor in the national interest exemption is that the individual will provide significant and unique contributions to an employer meeting a critical infrastructure need. Let's break that apart. First, significant and unique contributions are in addition and higher than what is required under a specialty occupation, which is the knowledge that they gain from a specific degree allows them to do that job, right? So significant and unique contributions would be in addition and above that. Secondly, that the employer is meeting a critical infrastructure need would really limit a lot of different professions. Now, let me list what those are. So that would be chemical, communications, dams, defense industrial base, emergency services, energy, financial services, food and agriculture, government facilities, healthcare and public health, information technology, nuclear reactors, transportation, and water systems. All right, so there's a lot of different professions out there. I'm a lawyer. You would not be able to get a lawyer with a law degree if it had to be in one of those infrastructure sectors. So I doubt that it will do that, but it'll be interesting to see what they glean from these new regulation they invented just last month to try to limit the number of H-1Bs that are coming into the country next. The next one is that the wage rate paid to the H-1B applicant meaningfully exceeds the prevailing wage by at least 15%. Now, this has been something that was discussed prior to the presidential bans and for a while on the prevailing wage. We were surprised that they did not have a prevailing wage lift in here because there was a lot of conversation they would. There were all sorts of things like meeting a minimum wage that may be above the prevailing wages, or a minimum wage of $100,000, or a minimum wage or prevailing wage that was the same across the country at the highest level. So what they did and they settled on for this national interest exemption was 15% above the prevailing wage. Will they do that with this new regulation? Fourth, the H-1B application's education, training, and/or experience demonstrated unusual expertise in the specialty occupation. Again, just meeting a specialty occupation is all that's necessary for the H-1B. They've added this new example of education, training, and/or experience being above it, right? So for an example, in what they give in the national interest exemption is that the H-1B applicant with a doctorate or professional degree or many years of relevant work experience may meet that standard, right? So are they going to have a minimum year of experience or an advanced degree as part of the new H-1B regulation? That'd be interesting there. And finally, the denial of the visa will cause financial hardship to the U.S. employer. So does the U.S. employer have to prove that if they don't hire this person, they're going to lose financially? These are interesting things. As referenced above, this interim rule seems to be a payback to the court system for really restricting how USCIS was conducting its adjudication of H-1B applications. The IT Serve Alliance case really blasted them on this situation, and this seems to be a fix for that. All they have left is specialty occupations, and I think they're really going to attack what that is on this sort of situation. So let's look at what the language is in the IT Serve case and about 4 other cases that came down in March of 2020 and see if they make a fix around what the court said that they could not do with their policy memorandums of 2020 and 2018. Number 3, significantly restricting third-party site occupations. What are third-party site petitions? Well, Company A has a contract to provide services at the location of Company B. And Company A sends a or a few workers or many workers to Company B to provide those services. All right. So this regulation is likely to focus on the work at third-party sites, conforming to the length of the project and the H-1B petition only being issued for the time period, and even tracking how often they are at the third-party site. This would be a fix to the IT Serve Alliance case. This would be a fix to the memos that they had to replace or remove because of the IT Serve Alliance. USCIS has targeted this business model since 2010 when it issued the Newfield memo and really amped up their disdain with it during the Trump administration with the issuance of the Contracts and Itineraries memo of 2018. So the unintended circumstances may be the benefit third-party hires have. A lot of hospitals, for example, now contract out their physicians to local doctors or their ER management companies. Can they no longer hire in this manner with this H-1B regulation? Big companies rely on staffing companies to hire and train and use companies to fulfill contracts or projects. The real question is, why is this inherently bad in the eyes of governmental agencies whose role is just to determine that the job requires a degree and accept the Department of Labor's certification that it will be paid the prevailing wage for the county and state where that job is located? The end result is government intrusion into the hiring processes of American companies that creates a chilling effect on our economy. Follow OnlineVisas' YouTube channel and turn on notifications to keep up with these evolving and important issues. Please like and share. For a free strategy session, go to OnlineVisas.com, the intelligent immigration platform. I'm Jon Velie, and we deliver dreams.